Hello guys! Welcome back to my channel. If you're new here, hello, I'm Mavis. And for today's video guys, it's going to be our third episode of the legal term. So for our third episode, I'm going to discuss about fortuitous events. So what is fortuitous event guys? So fortuitous event in the case of Metro Comcast Steel Corporation versus Allied Bank Corporation, guys. Fortuitous events is well defined as extraordinary events which are unforeseeable and unavoidable. If you may ask, guys, why is fortuitous event important? So fortuitous event, guys, is important, especially on law on contracts and obligations, because it may extinguish your liability or it may lessen your liability, and it is very important also in transportation laws, because in transport law it is required to have extraordinary diligence. So your paterfamilias or ordinary diligence is not enough or is not sufficient. The general rule in Article 1174 of the New Civil Code, fortuitous events, guys, extinguishes liability in the occurrence of unforeseeable events, or if foreseeable, it is inevitable. But there are some exceptions. The exception, guys, is that when the person responsible behind the occurrence of such fortuitous event is the debtor itself or the person liable itself, in three circumstances. So number one, when the law expressly declares such, or when there is bad faith. And number two, when there is assumption of risk, and that is the doctrine of created risk. And number three, guys, is when there is express declaration in a contract or in a stipulation. So that is hierarchy of contracts. In the case of One Appeal and Sons versus the Court of Appeals, the court stated there the requisites for a debtor or for a person liable to be extinguished from his liability on account of fortuitous events or acts of God. We have four. So the first one, guys, is that the cause of the breach of obligation must be independent of the will of the debtor. And the second one is that event must be unforeseeable and unavoidable. And the third one, guys, is that due to the occurrence of the event or the fortuitous event, there is now an impossibility on the part of the debtor or the person liable to comply with this obligation in a normal manner. And the fourth one, guys, is that there must be no participation and aggravation on the part of the debtor or the person liable as to the occurrence of the injury suffered by the injured party. Let's now discuss the three essential characteristics of fortuitous events. So number one is that the cause of the breach of the obligation must be independent of the will of the debtor of the person liable, meaning there must be no participation or aggravation on his part with regards to the occurrence of the injury that has been suffered by the injured party. The second one, guys, is there is an impossibility of foreseeing and avoiding the occurrence of the event. So for example, when there is damage of train passengers because the train was hit by lightning. And the third one, guys, is that due to the occurrence of the fortuitous event, there is now an impossibility on the part of the debtor or of the person liable to comply with these obligations in a normal manner. Take note, guys, that when there is a combination of fortuitous event and negligence, so when the proximate cause of the injury is the fortuitous event itself, there is already an extinguishment of liability. But if it is not the proximate cause of the injury, then it does not extinguish the liability, but it lessens. So the liability or the obligation now is converted to a monetary obligation for damages. So that's it, guys, for today's video. I hope you've learned something, and thank you guys for watching, and keep safe.